Members of the entering class, on behalf of the faculty, I welcome you to the law school and to the study of law. In the United States, the characteristic mode of legal instruction is the Socratic method, the advancement of understanding through the deployment of penetrating questions. So let me ask you one. Why are you here? I do not mean, why are you here this morning at convocation? Though I trust the answer to that will emerge in the course of my remarks. Nor do I mean, why are you here at the University of Iowa? Though I shall have something to say about the benefit of an Iowa law education. My question, phrased more precisely, is this. You wish to become a member of the legal profession. So why are you here at a university? In a past century or in another country, the route to the legal profession might have been quite different, having nothing to do with an institution of higher learning. Yet here you are, and we are, embarking on your training in the law within one of the nation's leading public research universities. Why? It's an important question. Let me begin to frame an answer by putting the question in historical context. For over 800 years, the study of law within the Western European tradition has occurred within the university. The connection between the revival of law and the formation of the universities goes all the way back to the dawn of the European university itself in the 12th century, one of the truly transformative periods in Western European history. One of the leading modern historians of the 12th century, Charles Homer Haskins, rightly called it a renaissance. Here's how he described it. The 12th century begins with the age of the cathedral schools and closes with the earliest universities already well established. It starts with only the bare outlines of the 7 liberal arts and ends in possession of the Roman and canon law, the new Aristotle, the new Euclid and Ptolemy, and Greek and Arabic works. For our purposes this morning, it's the connection between the emerging universities and the revival of law that should draw our attention. After the collapse of the Roman Empire in the 5th century, the system and learning of Roman law was essentially lost in Western Europe. But the Renaissance of the 12th century saw the rediscovery of Roman law, as well as a growing attention to the developing body of church law, known as canon law. The study of Roman and canon law can be found at the beginning of the 12th century in schools attached to the major cathedrals. But in the course of the 12th century, education migrated to the emerging universities, which in some instances grew directly out of a cathedral school. The University of Paris, for example, developed out of the community of clerical scholars associated with Notre Dame Cathedral. By the end of the 12th century, universities were established in Bologna, Paris, and Oxford, with others soon following: Cambridge, Salamanca, Padua, Naples, Toulouse. In each of these universities, law was a prominent subject of study. These were no ivory towers unconnected to the legal profession or the society at large. The graduates in law of the medieval universities went on to careers in government or the church, where they had a profound effect. The 13th century saw the promulgation of detailed law codes, directly influenced by Roman and canon law, in countries across Europe, from the Siete Partidas of King Alfonso X in Castile, modern-day Spain, to the Liber Augustalis of the Holy Roman Emperor Frederick II in Sicily. Even the Magna Carta in England, sealed in 1215, and therefore 800 years old next year, bears the imprint of Roman and canon law. So prominent in Europe was the role of Roman and canon law that it was known as the jus commune, the common, meaning universal, system of legal thought and practice. What about the other common law, the law of England? The law of the central government in England was called common law because it was the law common to the whole kingdom, in contrast to the local law of a particular manor, borough, or town. Just as the jus commune flourished in continental Europe, the common law flourished in England. Much of the story of English legal history is the story of how the common law came to dominate over local law. In medieval England, the royal courts were far more active than Parliament, so another sense of common law emerged: court-made or judge-made law, in contrast to statutes or legislation. This common law of England was not studied in the medieval universities of Oxford or Cambridge. Instead, it was studied in what was called the Third University of England, the Inns of Court in London. But the educational function of the inns broke down in the 17th century during the years of civil war and interregnum. The inns never recovered it. Instead, after some decades of essentially independent study and apprenticeship as the only forms of available training, education in the common law found its way to the universities, when, in the middle of the 18th century, William Blackstone began lecturing on the English common law at Oxford. The move from practice-based to university-based legal education had a profound effect. Blackstone's lectures, revised and published in the 1760s as Commentaries on the Laws of England, were the first comprehensive examination of English law since the 13th century treatise known as Bracton. Bracton had been a product of the medieval university study of Roman and canon law. It was an attempt to organize English law just as systematically as its Roman counterpart. In all the intervening centuries between Bracton and Blackstone, no such attempt was made. There were books by practitioners for practitioners, and some learned treatises on particular topics by authors such as Edward Coke or Matthew Hale, but nothing on the order of this comprehensive treatment. Blackstone's Commentaries was an immediate success, both in England and soon thereafter in the New America. It had a profound influence on the framers of our federal and state constitutions, and it is still cited by our courts, including the US Supreme Court. The 19th century saw the growth of university-based education in the common law, both in England and in the United States. Cambridge in 1800, Harvard in 1817, University College London in 1826, and, let's pick a final example at random, the University of Iowa in 1868. Everyone in this auditorium is the inheritor of a tradition of university education in the law that reaches back for more than 800 years, and that has shaped not only generations of legal professionals, but also the legal systems of nations. It is a proud heritage and a great responsibility. Your time with us is brief, and we have much to do. So let me ask my question another way. What will you accomplish here? Part of the answer will be individual to each of you, but let me offer an answer that I hope will be common to all. You are here because this university environment is where you can lay the best foundation for your life in the law. It will require intellectual rigor and analytical precision. It will also require professional judgment, emotional intelligence, and often teamwork. Your education here will challenge you in all the ways you expect, and it will push you to grow in ways you cannot foresee. The education you receive here matters. Your clients will depend on you for their businesses, their families, their reputations, in many cases, even their lives. Whether you work in the private sector or the public, whether you represent an individual or a multinational corporation, whether you advise a foreign government or a local school board, your clients will look to you for the most intelligent, insightful, careful representation possible. Your professional training and your professional responsibilities both start now. Take your education seriously. Your clients deserve it, and so do you. A serious education should not be a narrow education, and this is why you are training not in a law office, but in a university. Here, I want to emphasize 3 characteristics of the university, and of this university in particular. First, the university is a place of rich and robust intellectual engagement. Ideas matter. Words matter. Here, the strength of an argument depends on its logic, not on the speaker. There is no orthodoxy, no party line. In the words of the constitutional scholar Harry Calvin, the mission of the university is the discovery, improvement, and dissemination of knowledge. Its domain of inquiry and scrutiny includes all aspects and all values of society. A university faithful to its mission will provide enduring challenges to social values, policies, practices, and institutions. By design and effect, it is the institution which creates discontent with the existing social arrangements and proposes new ones. In brief, a good university like Socrates will be upsetting. However, the instrument of dissent and criticism is the individual faculty member or the individual student. The university is the home and sponsor of critics. It is not itself the critic. To perform its mission in the society, a university must sustain an extraordinary environment of freedom of inquiry. The neutrality of the university as an institution arises not from a lack of courage, nor out of indifference or insensitivity. It arises out of respect for free inquiry and the obligation to cherish a diversity of viewpoints. This is precisely the approach within the Boyd Law Building. Here you are encouraged to engage in free inquiry while respecting the diversity of viewpoints. A good education in the law depends on active learning, lively discussion, and intellectual engagement. Engage with your professors and with your classmates. And your education does not stop when the class period ends. The offices, hallways, and lounges throughout the Boyd Law Building are places of conversation and intellectual exchange. A second characteristic of the university is that its search for knowledge also has tremendous transformative potential. The medieval law faculties produced learning on Roman and canon law that changed European government and society. The lectures of William Blackstone at Oxford, published as Commentaries on the Laws of England, shaped not only the course of English law, but also influenced the American framers. The reach of the university has always been far beyond the ivory tower. This remains true today, and it is true here at the University of Iowa. Take full advantage of it. Take a course from Herbert Hovenkamp, whose treatise on antitrust has been cited more than 1,000 times by the federal courts and guides policy at the Department of Justice. Take a course from Arthur Bonfield, whose statutory drafting has shaped administrative law in this state and across the nation. Take a course from Josephine Gittler, who is working to improve the laws affecting senior citizens, and who was influential in securing the enactment a few months ago of legislation that will better enable Iowans to delegate financial decision-making in the event of incapacity. Take a course from Maya Steinitz, whose work in international dispute resolution has helped to resolve conflicts between multinational corporations and between nations. There are many other examples, but I trust you see the point. Through ideas and engagement, the professors here at Iowa Law are influencing law and policy, locally, nationally, and globally. We are eager to share our ideas and enthusiasm with you. A related point is worth emphasizing. Your education here is far more than what can gain you course credit. There is so much on offer in the Boyd Law Building. Each year, we invite an astonishing array of speakers, prominent lawyers, policymakers, and thinkers, people whose work is changing the law or changing how we think about the law. Make the time to hear them and engage with them. You will rarely have the chance once you are out in the workforce. These speakers are very much part of your education. This brings me to the third and final relevant characteristic of the university. The university is concerned with the full range of human inquiry. The university study of law is enriched by connections to and insights from other disciplines. In the words of William Rainey Harper at the beginning of the 20th century, a university school of law is far more than a training institute for admission to the bar. It implies a scientific knowledge of law and of legal and juristic methods. But these are the crystallization of ages of human progress. They cannot be understood in their entirety without a clear comprehension of the historic forces of which they are the product and of the social environment with which they are in living contact. A scientific study of law involves the related sciences of history, economics, philosophy, the whole field of man as a social being. No law office apprenticeship can provide this kind of education. You will find it only at a university. There are so many interdisciplinary opportunities at the University of Iowa, not only in other professional fields such as business, social work, medicine, or public health, but also in the liberal arts and sciences, economics, history, sociology, philosophy. All of these fields have valuable insights for law and legal practice. While you are here, try to take at least one course outside the Boyd Law Building. You and your legal career will be the better for it. Earlier in my address, I spoke with you about the Renaissance of the 12th century, the revival of Roman law, and the birth of the European university. Let me conclude by bringing us forward to another Renaissance, the more familiar Renaissance of the late 15th and 16th centuries. This was an era that saw a new enthusiasm for education, thanks to two important cultural influences. The first is what has become known as Renaissance humanism. Humanism was a movement of educational and cultural reform. It was a response to late medieval scholastic education, which had focused on practical, what we might call pre-professional education, training men for particular careers, for example, in theology or canon law. In contrast, humanists advocated a broader educational program, the Studia Humanitatis, or study of the humanities. For humanists, the educational program was to include ancient languages and the philosophy, literature, and history produced by classical antiquity. But this was not purely learning for its own sake. There was a purpose. Humanist scholars believed that classical education, combined with Christian morality, would create a more virtuous nation, and in particular, a more virtuous political and social elite. The late medieval aristocracy had been largely a military aristocracy. Humanists wanted them to be scholars, following in the model of the great figures of classical antiquity. Humanism began in Italy and then spread northward to France, Germany, the Netherlands, and England. The second cultural influence that spurred a new enthusiasm for education was the Protestant Reformation. In Protestant churches, the clergy were to be not only administrators of the sacraments, but a teaching and preaching pastorate, who needed to be well and broadly educated in order to serve as educators of the people. Protestant reformers also emphasized the importance of literacy at all levels of society. Protestantism was, after all, a religion of the book. God's will was found in the scriptures, and the more people who could read the scriptures, the better. Together, Renaissance humanism and the Protestant Reformation spurred a transformation in education at all social levels, but particularly for the social elite. In England, for example, the 16th century saw a transition from a pattern of noblemen and gentlemen being educated in the household by tutors or chaplains, to a pattern of being educated first in grammar schools and then in the universities of Oxford or Cambridge, and perhaps thereafter going on to the Inns of Court to study English law. The 16th century saw a massive expansion in the numbers of students at the universities and at the inns. The same flourishing of education can be seen on the continent, and I shall conclude with a specific example drawn to the attention of modern scholars by my former professor of constitutional law, Gerhard Casper. In the early 16th century, a young German by the name of Ulrich von Hutten was sent to a monastery to prepare for a career in the church. He fled the monastery, seeking a broader education within a university. In fact, he went on to study law at the University of Pavia in Italy. Later in life, he would become a scholar, poet, and publisher, a supporter of Martin Luther, and an important bridge between Renaissance humanism and the Protestant Reformation. In 1518, he wrote a letter to a friend describing his excitement in the world of new ideas. He wrote, "It is a pleasure to live. Studies blossom and the minds move." That is precisely what I and my colleagues on the faculty wish for you. Why are you here? You are here because this university education will prepare you for a life in the law. May your studies blossom and minds move.